Hi, I'm Marilyn Coors from the Center for Bioethics and Humanities. The dual foundation of informed consent in ethics and law is fairly unique and has always been of interest to me as a bioethicist. Ethics is focused on the responsibility to honor the approval and values of the patient, and the law requires compliance. So, I asked my colleague Annie Harrington to join me in a conversation about how ethics and law interact and how they differ.
I'm Annie Harrington. I'm a lawyer at Patton Boggs LLP, where I concentrate in health and safety law and policy. I've long been a student of bioethics. I have my master's degree in the field, and I sit on the ethics committee at Children's Hospital. Thanks so much for having me. We're going to begin with a 3-minute video, and then Marilyn and I will be back to take you through the origins and significance of this concept. Besides providing you with some background on the history of how informed consent became a cornerstone for protecting individual rights in clinical practice and research, this film introduces the key components of informed consent, which are competence, information, and voluntariness.
The need for informed consent arose in reaction to what are now considered unethical practices by researchers and clinicians in the early to mid-20th century and before. Historically, the relationship between a healthcare professional and their patient or research subject was more unequal than it is now. There was little expectation on both sides that a patient should question their doctor's decisions. Unfortunately, in some research, such as the infamous Tuskegee syphilis study begun in the 1930s, some healthcare professionals have used people as research subjects without their informed consent. In this study, researchers tracked the progress of the disease in subjects over many years, withholding penicillin that might have helped or even cured them. The horrors of the experimental practices used by the Nazi doctors during World War II led to the creation of the Nuremberg Code, which has as its first statement, "The voluntary consent of the human subject is absolutely essential." As society changed in the second half of the 20th century, individuals claimed more responsibility for their own lives and rights, as evidenced by the civil rights movement, feminism, and activism by minority communities, such as those suffering from HIV/AIDS or particular disabilities. This rise in autonomy as a human right has reinforced the importance of the informed consent process. Several criteria have been suggested for the informed consent process to be valid. The person must be able to understand the information presented to them and be able to make a decision. The person must be given enough information and at a sufficiently understandable level so that based on it they can make a decision. The person must understand the consequences of their decision. The person must be able to make their decision without being coerced. Finally, the person must give some indication of their consent, such as a verbal agreement or by signing a consent form. One way of thinking about the consent process may be like this. C. You are competent to make your decision. O. You are open to making the decision. N. You have the necessary background information to make the decision. S. You have the steps to be followed if you agree or disagree. E. You understand the explanation of those steps. N. You make your decision and notify someone. T. You tick the boxes and sign the form.
Informed consent is a relatively recent concept. A process for informed consent did not emerge within bioethics until the 1970s. The key ethical concept that best justifies informed consent is the principle of autonomy, which means respect for persons or self-rule, which could be interpreted as respecting the choices of persons, their privacy, identity, and/or physical boundaries. The legal origin of informed consent is quite different. Let's take a minute to review the key components of informed consent from the video. Competence means that only a person with capacity or a person's authorized representative, like a parent or family member, can consent to treatment. Open means that the patient is making a decision voluntarily and without coercion from another person or professional. Necessary and steps means the obligation of the professional to disclose the background information that a patient needs regarding the risks and benefits of all appropriate procedures and alternatives, including doing nothing. Explanation. A critical part of the patient's consent is understanding the explanation of risks and benefits of the procedure being considered. Notify and tick. A patient's informed consent is usually written and signed. The final step is necessary but not sufficient in itself, despite common practices. Without all of these components, there is no informed consent and the process is invalid.
Most of the legal requirements for informed consent come not from state or federal statutes, but from case law, meaning the collected opinions of judges and courts, usually as they consider patients' allegations that their healthcare providers improperly obtained their consent to treatment. The law of informed consent in the U.S. developed initially through the application of the tort law of assault and battery to medical practice and medical research. A battery occurs when one person engages in conduct that is intended to, and does, cause harmful physical contact with another person. In early informed consent cases, courts concluded that a healthcare professional committed a battery if the patient's consent was based on a substantial misunderstanding of the nature of the procedure or its consequences. In the seminal 1914 case of Schloendorf v. Society of New York Hospital, the plaintiff alleged that she had given consent to have her stomach examined under anesthesia, but that she did not wish to undergo an operation. Nevertheless, while the patient was unconscious, the physician removed a fibroid tumor from the patient's abdomen. In finding that this healthcare professional's failure to obtain consent amounted to assault and battery, the Supreme Court of New York famously noted, quote, "Every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages." The court recognized an exception in cases of emergency medical treatment, an exception that is still recognized today. It was not until the 1950s that a clear transition to the contemporary concept of, quote, informed consent began in the courts. The first case to adopt the notion that consent must be informed was the 1957 case of Salgo v. Leland Stanford Jr. University Board of Trustees. In that case, the plaintiff's legs were paralyzed after undergoing a diagnostic thoracic aortography. The plaintiff sued the physician for negligently failing to warn him of the inherent risks of the procedure. The California Court of Appeals held for the first time that not only was the patient's consent required, but that, quote, a healthcare provider violates his duty to his patient and subjects his or herself to liability if they withhold any facts which are necessary to form the basis of an intelligent consent by the patient to the proposed treatment, end quote. Thus began the modern concept that informed consent not only requires that consent be voluntary, but also that patients be fully informed by healthcare professionals about risks and benefits and other aspects of treatment.
Patients should be partners with professionals in determining their care. Moreover, patient preferences are clinically significant because patients who interact actively with healthcare professionals to reach a shared decision have greater trust and loyalty in the relationship, cooperate more fully to implement care, express greater satisfaction with their health care, and have better clinical outcomes, which is the ethical principle of beneficence.
Why is informed consent legally important? The cornerstone of the contemporary American approach to informed consent is the belief that the rights of patients to authorize their own treatment is a moral value worth promoting. In America, the assumption is that most patients want to know about and have the option of influencing the nature of their health care. Thus, the twin purpose of informed consent law is to protect patients by offering them money damages for harm from unauthorized or negligent treatment and to establish certain minimum requirements for physician behavior to avoid liability or lawsuits.
You will have to use your discretion and judgment to determine how to ensure that informed consent is properly obtained. For example, how do you know whether a non-native English-speaking patient who claims he does not need a translator fully understood your explanation of the risks and benefits of a complicated surgical intervention or your description of alternative treatments, even if the patient signed a consent form?
In evaluating whether consent was properly authorized or whether a healthcare professional violated the duty of disclosure, courts use the reasonable physician or reasonable patient standards. The reasonable physician standard closely parallels the standard used in medical malpractice cases generally. Healthcare professionals must disclose information to the patient regarding the procedure that a reasonable healthcare professional under the same or similar circumstances would disclose to a patient. Under the patient-oriented standard, The healthcare professional must disclose to the patient all information about a proposed treatment that a reasonable person in the patient's circumstances would find material to a decision either to undergo or forego treatment.
If a patient is unable to provide informed consent due to lack of capacity or a minor, the best interest standard applies. A surrogate decision maker must determine the highest net benefit for the patient or child among the treatment options. The surrogate or parent should take the patient's values, family values, and perspectives into account as they affect the balance of benefits to detriments.
In informed consent case law in Colorado, courts typically focus on what the healthcare professional disclosed to the patient rather than on what the patient understood. Ultimately, healthcare professionals must use their judgment to determine not only what to tell patients about the nature and purpose of the procedure, the risks associated with the procedure, including probability and seriousness of risk, and alternatives to the procedure, but also how to tell them in a way that is sensitive to the patient's informational needs. If a patient is unable to provide informed consent due to lack of capacity, a surrogate is appointed to make healthcare decisions on behalf of the individual.
The most common way we experience informed consent is by reading a form, checking a box, and signing our names. Except for something as simple as a flu shot, this practice does not meet the ethical or legal obligations of obtaining a truly informed consent. Remember the following important points about informed consent. Genuine and meaningful consent is an ongoing process, not a single event. A consent form signed by a patient may be the best documentary evidence that the process has taken place, but the consent form is only as informed and effective as the discussion that preceded it. The circumstances in which the consent process takes place are as important as the information conveyed in it. The setting should be conducive to effective communication. Technical details should be simplified and put in understandable terms. Questions should be encouraged, and the professional's demeanor should convey openness, patience, and sincerity. The ultimate goal of the informed consent process is patient understanding, not agreement with the professional's recommendation or the patient's signature on the form. Parents or other surrogates provide informed consent for the diagnosis and treatment of children, with assent from the child whenever appropriate until the age of 18. Current standards for assent by children for healthcare decisions accept that children from 7 to 14 years of age should be involved in the relevant details of decision-making about their care, even though parents or guardians provide informed consent. From 14 to 18, given evidence of capacity, adolescents and parents or guardians should collaborate on decisions. In cases of disagreement, consultation or mediation is encouraged, and the decision of the adolescent should prevail unless the law requires otherwise. What does the law require?
In most states, the age of majority is 18 years, and every person younger than 18 is a minor. As a general rule, minors, by law, are considered not mentally competent to consent to medical treatment. Parents or legal guardians are authorized to consent to medical or surgical treatment for minors. However, as Marilyn mentioned, there are a number of exceptions to this general rule. For example, if a healthcare professional feels that a parent lacks decision-making capacity or is not acting in the best interest of the child, he or she has an obligation to involve others for assistance in making treatment decisions. In the event that a parent is found to lack decision-making capacity, the courts may become involved. A guardian ad litem, someone who is appointed by the courts to protect the safety and welfare of the child, may be assigned solely to make medical decisions for the child. In most cases where this happens, the parent retains custody of the child. The law also recognizes that age does not necessarily render a person incompetent to make medical decisions. In every state, there are exceptions to the general rule that a parent or guardian must provide consent to medical treatment for a minor. Some states have mature minor statutes, which permit mature minors to consent to medical care in certain situations. A mature minor is considered a person under 18 who has the capacity to make informed healthcare decisions, based on a clinical assessment of the person's emotional maturity, age, experience, intelligence, and the decision to be made. In Colorado, there is no mature minor statute. However, a number of state statutes permit minors to consent to treatment. With the minor's consent, a healthcare professional may provide STD treatment, contraceptives, pregnancy medical care, or treat a minor for substance abuse.
We hope that you will think of your responsibility as a healthcare professional to obtain informed consent from patients before treatment, not as a means to avoid possible legal liability, but rather as a way to respect your patients' values and to recognize the legitimate and important role that patients play in shaping decisions about their own care.